And the number to call is 972-235-5555. Go ahead.
Hi, Mr. Malik.
Yes, go ahead with your question.
My question is, my mom filed the I-130 for my brothers, and it got approved, and like all the supporting documents, everything has been submitted to the NVC. And the last email I received in May the 2021, like they say they transfer my case to Mumbai Embassy, they're going to schedule an interview, and they're going to send me the email once the interview has been scheduled. I contact the congressman office, like what's going on and all that. The NVC sent the email to them that quota has been done for the last year, so they did not have any, they cannot schedule any appointment at this moment. Do you have any idea, when the new quota get open and how long it's going to be?
All right, please listen to the answer off air. Thank you
Thank
very
you
much
so
for
much.
calling. Look, this is an ongoing problem for a lot of people, especially for people that are in the fourth category, which is the brothers and sisters of U.S. citizens. There's a requirement by Congress that 17% of the cases, the visa availability numbers have to be assigned to this category. Lately, you can look at the historic numbers that are posted on the website. Usually the case numbers that are posted, it's never 17%, it's less than that. We have filed lawsuits against the NVC, and we've been successful for people's cases because they're not doing what they're saying they're doing. I mean, you contact the senator's office, they're going to give a boilerplate blank statement that they've already prepared. You're going to call their 800 numbers. They're really not going to do that, do much with that. The only way you're going to get some kind of response from them and to make them do what they're required to do by law is to file a writ of mandamus, which is a lawsuit against the Department of State to force them to do what they're supposed to do. There have been cases filed against the Department of State under this category, and they've been successful. So I wish you all the best. If that's something that you want to do, please reach out to my office, make an appointment, come and talk to me, and I can explain that further to you. But that is the only thing that I know that you can do which will actually produce results. I wish you all the best and good luck with that.
All the best and good luck. Good afternoon, Financial Radio. You are live on air, and your question, please.
I'm trying to apply for a tourist visa for to the U.S. for my sister and my brother-in-law, and they're saying it is not open till 2024. Is there anything I have to do?
What country are we talking about, Felix?
India.
So this is, again, the same problem with the Department of State. The whole world has recovered from COVID somewhat and come back to the normal working conditions and the working processes that were there, except for the Department of State. They keep playing games and keep telling people that they cannot do their job because of COVID, whereas really it's because they're incompetent. And the only way to do something about that is to force their hand. Unfortunately, because tourist visas, applicants don't really have many rights. You can't take that issue to the court, and you just have to wait and see what they will do. As far as immigrant visas are concerned, when they make people wait, you can file a lawsuit, which is known as writ of mandamus, and you can ask the court to force them to do their job. Now, coming back to your question, Felix, there have been some updates where people who are applying for tourist or business visas who have previously had visas can now get a waiver to the interview, and you don't have to wait for a very long time, and you can take advantage of that if that is available in the country where the applicant is a citizen of or resides. Now, I don't know if your brother or mother or your family members who need to apply for visa have previously had visas. If they have had visas previously and they have expired recently, they can definitely take advantage of the visa waiver program through the Dropbox system. However, if they've not had visas in the past or which have recently expired, then unfortunately they're not going to have much of a choice but to apply and then wait for an interview, which is taking a long time in a lot of countries. It's not only an India issue or a Mumbai consulate issue that's happening all over the place. They are doing this to a lot of people, and believe me, the pressure is on them to do something about that. I wish you all the best, and I hope that helps you.
Please switch off your radio and ask your question.
So, as you all know, like, it's a layoff season. So I got laid off recently, and I am on my garden leave, and I have some active employment for next couple of months. My question is that after that, my employer in the termination letter said that they would revoke the H1. Would it affect my wife's H4 EAD? And also, before all this happened, I had planned for visiting my home country, and I had done that all the DS-160, and I took the appointment and everything for the coming months, like June, July. How do I get to update the DS-160 once I get a new job, or do I have to reschedule? How do I manage that? Is it possible, or I have to start from scratch again?
All right. Well, there's a lot of questions I'm going to try to answer. I mean, usually we ask people to basically limit their questions to one question because we cannot go into very much detail because we're on the radio. But look, unfortunately, yes, there's been a lot of layoffs. If you've been laid off and your I-140 was approved for a time for less than 6 months, then there could be a problem. If you have had an I-140 which was approved for more than 6 months while you were with the employer, then you can carry on the priority date at least. So that's one thing. Now, if the I-140 is revoked, then yes, you will. That will affect your wife's H4 EAD because that requires a valid I-140. Now, you can certainly ask another employer to file an I-140 for you, and you can carry on the priority date if it is within the same category. Now, having said that, you need to understand if the information is significant, then you can certainly do a new form and DS-160. Now, if that is going to delay your interview or your appointment by a lot, then I would just say go to the interview and let the officer know about that change, and that should be okay. I wish you all the best with that.
Thank you. All the best with your move on. Good afternoon, FunAsia Radio. You are live on air. Your question for Mr. Malik, please.
Quick question on my H1B term. So my H1B term, 6 years, is going to end in March, and I got an extension after that till 2024. And the question here is, my I-140 got approved just 15 days back, and if my current employer lay off me, will my priority date still valid? I'm hearing some rules like my H1B priority date will be valid only if I stay with my employer for 6 months after the I-140 approval, like initial I-140 approval. So will I be able to transfer to a different employer after that? I'm not 100% sure. So can you please help me with that?
All right. Please listen to the answer off air, Dipti. Yes, you are hearing this correctly. For your priority date to be retainable or where you can use that in the future, you will need to stay with that employer after the approval of the I-140 for at least 6 months. If you don't do that, then you will not be able to retain the priority date. It will not be usable by the future I-140 in that category. You would have to start all over again. So do your best to stay with this employer for at least 6 months past the approval of the I-140. I wish you all the best.
Here we have Mr. Malik on the airwaves of FunAsia Radio answering your question, and this one from law offices, the Malik&Associates. Welcome back, Mr. Malik.
Thank you.
Good evening, Fun Radio. You are live on air. Your question, please.
Hi, Adam. Thanks for picking up my call. And this call is regarding my H1. So basically, I have a stamping. I have an approval 2020 to 2023 May, but that was never stamped because I never left the country. But right now, I have an approval already received that starts from May 1st, 2023 to May 1st, 2026. So my question is, I'm planning to go to India next month and then get it stamped. So I'm going to get the I-797 of the approval of which is going to start from May 1st to 2023 to May 1st, 2026. That's what I'm going to show and then get it stamped. So my question is, am I still eligible to come back before May 1st, 2023? Or I need to hold till May 1st to come back?
I understand. Please listen to your answer off. Okay, so you have an approval right now that's valid until May of 2023, and then one starts from May of 2023 to 2026. So when you go, take both of them with you. So when you take both of them with you, they're not going to give you a visa starting May of 2023. I mean, obviously, you still have an I-94 that covers the time between now and 2023 May. So if you take both of the approvals with you, they'll see that, and they'll give you a visa with the validity starting right away. So I don't think there'd be a problem for you to come back, but make sure you have both of them with you. I wish you all the best.
All the best. Taking my next call on air. Good evening, Fun Radio. Your question for Mr. Malik, please.
Hey, good evening. Thank you so much for taking my call.
Sure.
So I have a question with my wife. I'm on H1B. She's on H4 dependent. She was a doctor in India and she just joined me here 3 months back. Is she eligible for applying an EAD, or is there anything that needs to be completed as a prerequisite being a doctor? Is there any special consideration?
Approved, sir?
Not yet. It has just been in the process.
Okay. Well, until your I-140 is approved, she does not get an EAD, sir. You have to wait until you get your I-140 approved.
So not even with the doctor categories, there are no special provisions?
No, there's no special provision. She can apply for her own green card if she wants to and see if she qualifies under any specific category, but she's not going to get a work permit until that happens.
Thank you
I
for
wish
your
you all
call.
the best, sir.
Okay.
Thank you very much.
Ask your question for Mr. Malik, please.
So my question is, my H1B is active, green card is in process, and my attorney said that the green card will be probably done by August this year. Meanwhile, my wife, who is on H4, also doing her master's on H4, I was thinking to change it to F1 this summer. Do you think that is a good move, or shall I just wait for me to get my I-140 approved?
Why would you want to change it to F1? Is your H1 coming to an end?
No, my H1 actually renewed last September, but I haven't stamped it, just to speed up her employment. That's it, because I think my attorney told me that we cannot file her H4 EAD until I get my I-140 notice, which is August, and then potentially looking at 4 to 6 months for her to get her H4 EAD. So we're looking at December, January next year. But if she can get her F1
then she can
status,
get the OPT. Is that what you're talking about?
Yes, sir.
Okay. All right. Please listen to the answer off air. Look, I mean, if you want to do that, you can certainly do that. You can get her on F1 and then get the OPT, but there may be complications on how quickly you can get her status adjusted or converted from H4 to F1 now that she's coming towards the end. You're going to have to keep one semester there before you do that, and then there might be delay. I mean, I don't know if she has 12 or 9 credit, whatever full-time is for master's students. If she is a master's student, still remain. So as long as all the logistics are doable and she files from H1 to F1, and it happens within time before her next semester starts, yes, that theoretically on paper that idea sounds good, but there could be other complications. I mean, honestly, I would stick to where you are because it doesn't seem like you're going to have other problems. If your I-140 gets approved, wonderful. If not, then she'll find her own job and get her own H-1, and that would be directly from H-4 to H-1. But, I mean, if you want to take that chance and with that risk that things can be delayed, and while you go on to F-1, I mean, you can certainly do that. That's up to you. I wish you all the best.
Officer of Mr. Malik is
And
214.
Navneet, I think after you came in today, everybody's calling his H-1. What happened to the rest of the world?
I
There's
have
nobody
no-
else other than H-1 out there?
Oh, there
I
must
think
be.
you told them to only call H1.
That's what. I had made an announcement and a disclaimer just before your show started. Absolutely. Please make me show good by asking a different question than immigration.
Yes.
Welcome.
Hi, good evening, Nandita ji.
Another good evening.
At last, I got hold of you,
Yes.
your phone. Yeah. Good evening, Mr. Malik. I am not having the H1 question. I am having
See?
something else.
Good, thank
So,
you. Yay.
My question is, like, we have been overseas recently for a couple of weeks, and by the time we came in, we had our green cards in our mailbox. So when we came in, we showed our EADs, travel parole, and they have paroled us. But when we looked our, post box, we have our green cards. So what we need to do now? Like, we are good, or we need to go back and come in again?
Well, if you want to take another vacation, sure. I think you want to.
Congratulations. That's wonderful. Please listen to the answer of fair. Mr. Malik will just answer it.
Well, first of all, congratulations on becoming a permanent resident. I know that's a big, big step that a lot of people want to take, so congratulations. Look, you've already been paroled into the U.S. You're already a permanent resident by the virtue of your green card. But, I mean, if you want to feel comfortable just so you're stamped into the country as an LPR, you can certainly do that. You can go take a trip to either Mexico, Canada, Bahamas, Caribbeans, wherever you want to go, and then come back with your green card. But it's not necessary because you are already a permanent resident. That's fine. You can you can really just be the way it is. So I wish you all the best, and congratulations once again.
Congratulations. Wonderful news. Good evening. FunAsia Radio, you are live on air. Your question for Mr. Malik, please.
I think my hours have changed, driving hours have changed. I'm not calling for an H1 question. I'm just calling to thank Mr. Malik for doing such a good community service.
Awesome.
Well,
Thank you so
very
much.
much. What is your name, ma'am?
My name is Geeta. I listen to this program very often, but just wanted to thank you. You do such a good service. Thank you, sir.
Well, Geeta, thank you very, very much. I really appreciate it, and that is the whole idea. I mean, as attorneys, we have our clients who come into our office who pay for the service, but sometimes there's people in the community who are unable to afford legal advice or service, and that's why we do it for free on the radio, on air, and it can, not only serve the people who call in with a question, but a lot of the people in the community who are listening in can also benefit from getting those legal questions and answers and information. So thank you very much for calling. It means a lot to me.
Thank you, sir. God bless you and keep up the good work.
You are live on air. Your question for Mr. Malik, please.
Yeah, my question is, I'm with the current employer. My I-140 approved, and it crossed 180 days. Now it's almost 10 months. Now I moved to a different vendor. So other vendor has to reinitiate the I-140? Is vendor A can revoke the I-140? If like that, how can I proceed? Is there any issue for H1 extension further?
That is correct. Your I-140 is approved, but you've been with the employer for more than 6 months. As soon as you leave and go to a new employer, the previous employer who had filed the I-140 can revoke it at any time. That is correct. For you to continue to get your extensions, you need a valid I-140 approved I-140, and so you're going to need another employer to file an I-140 for you if the previous one is revoked. Now, having said that, when people change employers, I would recommend that they get something in writing from their new employers that they will file a new I-140 right away, as within a certain amount of time, let's say 30 days, 60 days, 90 days, whatever it is, because if you don't do that, that could create problems for you, and your previous employer is at free, basically can freely revoke the I-140 that they filed for you. So I wish you all the best and good luck with that.
Good luck with that. Please switch off your radio and ask your question, please.
Okay, so this question is for my brother who is here on J1 visa, the internship visa, and he has a condition, 2 years conditions apply. So I want to know what are the options for him to be switching to other visas, or what are the other avenues we could be looking for?
Please understand that, asking what other options they have available is a very loaded question. I can't answer that and go into all the details. But what I can tell you is that if somebody has a J1 visa with the 2-year residency requirement condition, there is a waiver available that you have to file. You have to get certain documents from your country, from the embassy, the non-objection certificate, the NOC, and some of the other things. And there is a process. The waiver is I-602 waiver, I believe. You have to file, and that can give you basically a waiver for the residency requirement. And then later, if you adjust your status, you don't really have to worry about that. Once that's done, you can go into F1 or other categories of visas, and that shouldn't be a problem. I wish you all the best with that.
Thank you. Wish you all the best. Good evening, Parijo Radio. You are live on air. Your question, please. Please switch off your radio.
Actually, my I-140 approved in the month of October, 3-4 months back, and my employer is not sharing the approved copy. So what I did is I made use of e-request option to get an duplicate copy when we lost the approved petition in the mail or something. So what happened is, like on January 4th, it says again the I-140 has been approved. The status is showing again on January 4th, I-140 has been approved. How can an approved petition, can it be again approved by USCIS? Why it is showing?
I understand, sir. Please listen to the answer off air because we're running out of time. Let me quickly answer your question. A petition cannot be approved again. I mean, there could be something in the system, a glitch or something that they did. Maybe when you requested that document again, they did something in the system and it shows a new approval date. But or sometimes it can be approved, revoked for some reason, then reapproved. So it could happen for various reasons. I don't know what it is. But I mean, how do you know that the I-140 that is approved is for you, or if the employer filed it for you if they're not sharing anything? I mean, if they're not sharing anything, I mean, it's obviously because something is going on. I mean, if you can't trust your employer, then you need to find other ways to have somebody else file an I-140 for you, because maybe they're wasting time with you. I mean, they're wasting your time, and maybe they're playing games, and maybe they just want to keep you on by delaying your I-140 approval and playing games to gain benefit. But in any way, you need to find out what's going on, and I wish you all the best because we're running out of time, and we will see everybody next week right here on FunAsia.
Awesome. Wonderful to have you, Mr. Malik, and thank you. And the number to call your office is 214-881-2100.